legal sense, amendments must also be procedurally admissible. The chair may be called upon to rule amendments inadmissible if they go against the principle of the bill or beyond the scope of the bill, both of which were adopted by the House when it agreed to the bill at second reading, or if they offend the financial prerogative of the Crown. Amendments have been given a number in the top right corner to indicate which party submitted them. There is no need for a seconder to move an amendment. Once moved, you will need unanimous consent to withdraw it. During debate on an amendment, members are permitted to move sub-amendments. Approval from the mover of the amendment is not required. Sub-amendments must be provided in writing. Only one sub-amendment may be considered at a time, and that sub-amendment cannot be amended. When a sub-amendment is moved to an amendment, it is voted on first. Then another sub-amendment may be moved, or the committee may consider the main amendment and vote on it. Pursuant to the order adopted by the House, if the committee has not completed the clause-by-clause consideration of the bill by 6:30 p.m., the chair shall allot each party no more than 5 minutes for each of the remaining amendments and clauses, and the committee shall not adjourn the meeting until it has disposed of the bill. Finally, if members have any questions regarding the procedural admissibility of amendments, the legislative clerks to my right are here to assist the committee. However, they are not legal drafters and cannot respond to legal questions. So I thank the members for their attention and wish everyone a productive clause-by-clause consideration of Bill C-70, no matter how long it shall take. So I would like now to welcome the officials with us. With the Canadian Security Intelligence Service, we have Sarah Estabrooks, Director General, Policy and Foreign Relations. We have Maria R. Senior Analyst, Strategic Policy. With the Department of Justice, we have Jennifer Poirier, Senior Counsel, Mark Scrivens, Senior Counsel, Karine Bolduc, Counsel, and Kieran Dyer, Counsel. With the Department of Public Safety and Emergency Preparedness, we have Richard Bilodeau, Director General, Saskia Van Batten, Director, David McIntyre, Acting Director, and Fenton Ho, Acting Director General, who is in the public gallery apparently. Clause by clause consideration. Okay, so pursuant to Standing Order 75-1, consideration of Clause 1, short title, is postponed. The Chair calls Clause 2. So there are no amendments submitted to Clauses 2 through 33. Do we have unanimous consent to group them? Yes, we do. Shall Clauses 2 to 33 carry? Clauses carried. All right. That brings us to Clause 34. The amendment is block number 1. Monsieur Villemure, do you wish to move it?
Merci, Monsieur le Président. J'aimerais.
Thank you, Mr. Chairperson. I'd like to move the following amendment. It's more semantic than anything else, and the purpose is to ensure that the offence, that it be, in fact, amended so that it's, there's an equivalent with the English version that is more accurate.
Nous sommes d'accord avec l'amendement.
We agree with the amendment.
Okay. Shall BQ1 carry?
Yes.
Yes? Carried. That brings us to CPC1. I guess that would be in the name of Mr. Shipley, or?
That'd be in my name, and I'll.
Okay.
Pardon me, Mr. Chair. That would be my name, and I will move that amendment, and I'll reserve any commentary to my colleague, Mr. Chong here.
Yeah, Mr. Chair, this doesn't change the substance of the intent of the clause, but simply clarifies that the person being briefed may be told of personal information as it relates to themselves, allowing them to be briefed, and that amendment comes out of testimony that the committee heard from CSIS officials.
Okay, thank you. Any further, Mr. Gahir, please.
Chair, I'd like to move a sub-amendment, if I can.
You have submitted a sub-amendment in writing? Do we have to do that, right?
Can you ask him?
Do you have it in writing? Can you submit it?
Yeah,
in
yeah,
writing?
I think it's already been submitted.
Okay,
It's going to be submitted.
okay. That's a requirement. right? Mr. Gahir, it's going to be a long night. If you would move the motion, we will then suspend and the analysts can have a look at it okay?
Sure. I move the sub-amendment.
Can you say, can you read them in?
Yeah, sure. No. So look, the proposed language, which I'll propose in a minute, would still include a general prohibition on the disclosure of personal information about Canadians and persons in Canada, but it would add an exception to ensure that CSIS could disclose an individual's personal information to that individual as part of a disclosure to build resiliency against threats. And in terms of the actual edit to the language itself, in 2.1b, after the comma, at the end, the last sentence, I would change it to other than personal information of the individual to whom the information is disclosed. And in C, I would change it to, after entity, after the end of that sentence, comma, other than the name of the corporation or entity to which the information is disclosed.
Mr. Chong,
Mr. Chair, could he repeat that, please?
go ahead, please.
So in 2.1b, the final sentence after the comma would be changed to other than personal information of the individual to whom the information is disclosed. And in C, after the end of entity, the end of the sentence, I would put a comma, and I would put other than the name of the corporation
He's supposed to be modifying.
or entity to which the information is disclosed, period.
Thank you, Mr. Gahir. We'll suspend for a few minutes while we get squared away here. messes up the rest of the bill. What is written in the actual text of this is acceptable, right? So what is shown here on this summary is
Sub-amendment.
so the sub-amendment, which does not affect Part C here, is acceptable. I'm sorry? Go ahead.
Sure, but I think we would still want the edit for B, right?
Yes.
Which is just a small edit from "and" to "the." I think we're clear.
We're all clear?
Yep.
That makes all of you.
So,
but not
so,
me.
so just to clarify, Mr. Chair, you've ruled the sub-amendment as it relates to C out of order,
Yes.
but you've ruled the amendment, the sub-amendment as it relates to B as in order.
Yes. So I'm a little confused by this because on this, which is a summary of your amendment put into the text, your amendment doesn't have this part, this sub C in it, right? So the amendment itself is good. This depiction of the amendment is kind of off. So your sub-amendment, Mr. Gahir, to modify C is, that part, it doesn't work. But the modification to CPC 1 that is good is good, in my understanding.
On the sub-amendment first, and then...
Yes, we do.
Yeah, okay.
Is there any more comments on, any more confusion we can add to the sub-amendment? No? All in favor of the sub-amendment? Right? So any further comment on the CPC 1 as amended? None? All in favor? I take that as yes. So CPC 1 as amended carries. That brings us to clause 34 with no amendments. Shall clause 34?
As amended. Clause 34.
Oh, sorry. That was clause 34. So shall clause 34 as amended carry? Yes, okay. So there are no amendments submitted to clauses 35 through 41. Do we have unanimous consent to group them? Yes? Shall clauses 35 to 41 carry? Yes. Thank you. So that brings us to new clause 41.1. That is Government 1. Who wishes to move? Mr. Gahir, go ahead.
Sure. Chair, we'd like to move Government Amendment 1. This amendment will ensure that CSIS officers and those who aid CSIS have the same legal liability extended to them under the new warrant provisions that exist in the current CSIS Act. I can read the summary if you want, or we can just leave it to the officials to explain any other details.
If there's any questions to ask, because officials, please do. Are there any questions? Mr. Gahir, are you asking questions of officials? No.
It's fine.
Is there any discussion on G1? Let us get through this G1. Is there any discussion on G1? Are we ready to vote on it? All in favor of G1? Carried. So that will. So we have a vote on the floor.
I believe there's agreement between the parties to just take brief breaks in between the votes and have unanimous consent to carry through while we vote through these various votes.
So I understand there is a unanimous consent. Is that correct? Yes. Okay. So let's get democracy underway here. Oh, okay. Well, in that case, that brings us to clause 42 and NDP 1. Mr. McGregor, do you wish to move NDP 1?
Yes, Chair, I do wish to move NDP 1. So small change to clause 42, simply changing the word shall to may. And the rationale is that, CSIS has been given a significant new production order and warrant powers, and I think that there have been some concerns from civil liberties groups on this. So to address this, we propose changing it to allow a little bit more leeway.
Okay, any discussion? Shall NDP 1 carry? Yes? Carried. So this should be on this,
So
right?
shall clause 42 carry?
Yeah.
Sorry.
So shall clause 42 carry, which includes the G1 and NDP 1? Shall clause 42 carry? Yes? Carried.
Yep. As amended.
Okay, as amended, sorry.
We suspend,
Open now?
pause just for a minute to vote, Mr. Chair.
Absolutely. So we'll pause and everybody gets to vote. It's a fascinating process. To group them. So shall clauses 43 to 52 carry? Thank you. That brings us to clause 53 and NDP 2. Mr. McGregor, do you wish to move NDP 2?
Yes, Mr. Chair. So as members know, Clause 53 is a rather large clause with all of those significant amendments to the Security of Information Act. And I was just sort of recognizing that the sentencing is pretty strict in a lot of these, and I understand that absolutely for the crimes being committed, we do need to have those strict sentences. But I'm just sort of making some changes to make sure that instead of having the word, I believe, shall be served consecutively, is that they may be served consecutively. And so, again, there's still an option for a judge, based on the circumstances of the case, to impose consecutive sentences. But there's also an option to give a little bit more leeway, because, again, the circumstances of each case can vary considerably. So that's what my amendment is attempting to do throughout Clause 53.
Mr. McGregor, is any discussion? Mr. Gahir?
Yep. Thank you, Chair. So we see that this motion would give a sentencing judge the express discretion to apply a consecutive sentence, but they wouldn't be required to impose one. So we just wanted to ask the officials, perhaps, what the thought process was during the drafting of this language.
Thank you for that question. The provisions that require a mandatory consecutive sentence be imposed for the new Security of Information Act offenses mirror similar provisions in the terrorism offense regime in the criminal code and the organized crime regime in the criminal code, which similarly require the imposition of consecutive sentences for convictions of those offenses. So the intent in the Act is to reflect the seriousness of foreign interference offenses and to suggest that they are equally as serious as terrorism offenses and organized crime offenses. I will additionally point out that Section 718.2 sub C of the Criminal Code allows the sentencing judge discretion to ensure that the overall total sentence is not unduly harsh or unfair in the circumstances.
Thank you. Any further questions? Are we ready to vote on this amendment? All in favor of, shall NDP 2 carry?
Can we ask for a
Recorded vote, Mr. Clerk, if you would.
Oh, okay.
Mr. Biddle?
No.
Ms. Zaid?
No.
Mr. Gay?
No.
Mr. McDonald? Mr. Longfield,
No.
Mr. Caputo,
No.
Mr. Chung,
No.
Mr. Matz,
No.
Mr. Shipley,
No.
Monsieur Villemur,
Oui.
Mr. McGregor.
Yes.
Yes. 2 yeas, 9 nays.
Thank you. The amendment is negatived. That brings us to the end of Clause 53. Shall Clause 53 carry? Yes. All in favor, yes? Carried. There are no amendments submitted to Clauses 54 through 60. Do we have unanimous consent to group them? Yes? Shall Clauses 54 through 60 carry? That brings us to Clause 61 and CPC 2. Mr. Caputo, if you...
Thank you, Mr. Chair. At this time, I will be moving CPC 2. This is a very basic amendment as it relates to essential infrastructure at what stage in its development or construction that it's in. Thank you.
Any discussion? No discussion? All in favor of CPC 2? Carried. That brings us to NDP 3. Mr. McGregor.
Sorry, Chair, I'm just getting to the page here. Yeah, okay, so this amendment is based on the testimony we received from Ms. Emmanuelle Rayo. And during her testimony, she was just saying that if we didn't specify that it was the Attorney General of Canada, then it would be the Attorney Generals of the provinces. And just given the seriousness of these criminal code changes, basically, sabotage, I thought it best that we specify that it's the Attorney General of Canada that is actually referred to. And so a pretty simple amendment, just changing reference to which Attorney General it is.
Mr. Gayer.
Great, thank you, Chair. So the prosecution of most criminal code offenses, as we know, including sabotage, is the responsibility of the provinces. But I'd like to ask the officials their thoughts on the drafted language.
Thank you. It is correct that most criminal code offenses, and the sabotage offense appears in the criminal code, are prosecuted by provincial prosecution services. Sabotage in its current form in the criminal code is prosecuted currently by provincial prosecution services. The effect of this amendment would limit the consent for the commencement of a prosecution to the Attorney General of Canada, but does not specify that the ensuing prosecution would be conducted by the prosecution service, Public Prosecution Service of Canada. So the effect would be that the consent would have to be provided by the Attorney General of Canada, and then the ensuing prosecution, if it in most cases related to matters within the provincial jurisdiction or that are normally prosecuted by provincial prosecutors, would then continue to be prosecuted by a provincial prosecution service. That's my reading of the effect of the provision. I will also add that in Section 2 of the Criminal Code, Attorney General is defined as both Provincial Attorney General and the Attorney General of Canada.
Okay, Mr. McGregor?
I just had a question for Mr. Scrivens. Sir, you had said most offenses are prosecuted by provincial attorney generals. Can you just clarify what the exceptions might be?
There is some some exceptions. For example, the terrorism provisions of the criminal code can be prosecuted by the prosecution service, the Federal Prosecution Service, and in general usually are prosecuted by the Public Prosecution Service of Canada.
So I think, Mr. Chair, based on that response and the seriousness of existing criminal code offenses that are looked after by the Attorney General of Canada, I think there is potentially an argument to be made, given these amendments to the criminal code and the seriousness of the offenses listed. You could find an argument that's saying it's in line. But again, it's up to colleagues to determine whether that is so.
Okay, is there any further discussion on this amendment? Shall NDP 3 carry? Yes, Ms.
Sorry, I want you to finish the vote call and then.
Oh yeah. So shall clause 61 as amended carry? Yes. Sorry, Ms. O'Connell.
Sorry, apologies for being late. I had to finish question period in the House. I just wanted to quickly apologize and retract from my comments about Mr. Villemure at the last meeting, and I really look forward to working with him on this committee and on this important bill. Thank you, Chair.
Thank you, Ms. O'Connell. So there are no amendments submitted to clauses 62 through...
Another
vote? Well, let's get that done. Submitted to clauses 62 through 112. Do we have unanimous consent to group them? Yes. Shall clauses 62 through 112 carry? Yes. Merci. This brings us to clause 113 and NDP 4. Mr. McGregor.
Sorry, Chair. You said NDP 4?
Yes.
Yes. Okay. All right, so this was an amendment to the bill that was brought forward by my colleague Jenny Kwan, a member of Parliament for Vancouver East. So amending on page 75, line 25, and just further clarification on part F of the definition of political or governmental process. So basically, although the Director General who appeared from Public Safety Canada said it was their interpretation that leadership contests could be or would be included, Ms. Kwan felt it was appropriate to further clarify this just for a little bit more specificity in the law.
Thank you, Mr. McGregor. So if NDP 4 is adopted, BQ2 cannot be moved due to a line conflict, okay? Is there any discussion on NDP 4? Mr. Gahir.
Thank you, Chair. I'd like to just ask the officials that even without this amendment itself, we know that would foreign efforts aimed at influencing the appointment and elections within a political party, including leadership contests, would they be captured under this act?
The intent of the legislation was to be fairly broad with political processes, and it is our interpretation and intent that those things would be captured under the current drafting of Bill C-70.
Any further discussion? Mr. Chong.
Yeah, Mr. Chair, we'll support this amendment because it provides greater clarity of what officials have said are the intent of the bill's clause.
Discussion. Mr. Gahir.
Thank you, Chair. So I believe that the amendments offered to the Security of Information Act also defined a political or governmental process using the unamended definition. So can the officials confirm that that is the case?
Thank you for the question, Chair. It is true that there is a similar definition within Section 20.4 at Clause 113 of the Act, and so the effect of the amendment would be to change the definition in one place in the Act and not change it in the other place in the Act.
If I could just ask a follow-up question.
Mr. Gahir.
So what are the consequences of having those two different definitions?
It's difficult to predict definitively, but there is the possibility that a judge might determine subsequently that this was done intentionally and that a different interpretation should be applied to the two different definitions provided to the same term.
Any further discussion? Ms. O'Connell.
Thank you, Chair. Just following up on that, then, if a judge could determine that there are two potentially contradictory definitions, then they could rule one in order and one not? And does this not risk? And because of the constraints we're under this committee, we can't go back and create the matching definitions in SOIA. Is that correct?
Sorry, I didn't intend to cut anyone off, Chair. The concern is that in a subsequent interpretation of the term, that a court or the lawyers involved don't have time to consult this record, which would show that the intention is to create a non-exhaustive list in both places in the Act that captures leadership contests and nomination contests. That is the risk.
So you feel comfortable that the language as is, unamended, covers the additional wording, like things like appointments, elections within a political party, including leadership contests, that is part of the existing Act without defining it so that there wouldn't be confusion without having the same defined language in the other part of the Act?
Thank you, Chair. The intent in the in the offense provision and in the registry provision is the same, which is to create a non-exhaustive list that captures nomination contests and leadership contests, as well as those other internal mechanisms and procedures within the democratic aspects of a political party. But the effect of this amendment would simply clarify that leadership contests are included in the registry portion of the bill. It would not similarly clarify it in the in 20.4, the proposed 20.4.
Thank you. So, Chair, with that being said, I think if the intention of the act are to include these things, which I feel confident it has been, I worry that this amendment, and we then can't support it, this amendment would cause confusion because we are constrained at this committee to be able to go back and create the same language in the rest of the act. So I feel comfort in all of these political activities that are outlined in the amendment are already covered, and I don't want to cause confusion of the implementation of this act, so we can't support it. Thank you, Chair.
Thank you, Chair. Mr. Scrivens, am I correct in, like, these are two very different acts that serve different purposes? I mean, Part 4 of this bill is it's enacting a brand new act. It's setting up a registry, which I think is the transparent foreign interference that is happening, whereas these important amendments to the SOIA are really, I think, attempting to go after the more clandestine, deceptive methods of foreign interference. So am I correct that, these acts are serving different purposes? Would they ever cross each other in any way to cause that kind of confusion, since they're going after two very different things? One is very public, a public registry. One is under serious offenses under the SOIA.
Thank you for the question. It's our view that we can't rule out a circumstance, given that the registry creates criminal offenses. We cannot rule out a circumstance where 20.4 of the proposed 20.4 of the SOIA would overlap with a set of circumstances that would give rise to offenses under the registry proposal.
Any further discussion? Mr. Chong?
Yes, is the Security of Information Act definition, was that contained in Part 2 of this bill in front of us, Mr. Chair?
Yes, it is.
And what I remember our witness referring to a particular clause, 20, I believe it was. I'm trying to find it in the bill. That's page 30. Okay. Mr. Chair, when I read that section, on page 30, I don't see any reference to a leadership contest.
Let's carry on this discussion after we have a vote. So. your discussion.
Yeah, I just wanted to understand whether on page 30 in the definition of political or governmental process, part F, which refers to the nomination of a candidate, would include the selection of a leader of a registered political party.
Thank you, Chair. I think the best way to answer this question is to indicate that where the clauses use the term includes, the following examples are intended to be examples of circumstances where the offense applies, but the intention is to indicate a non-exhaustive list of examples, and the same framework was adopted for the registry as well.
Okay, Mr. Chair, we're armed with that information, that clarification. I'm prepared to defer to officials on this and their expertise. Thank you.
Can we just suspend for 1 minute?
Sure. We'll suspend for a brief time.
Unanimous consent to withdraw NDP 4.
Do we have unanimous consent? Yes, we do. Okay. That brings us to BQ2. Since NDP 4 was not adopted, we can now move BQ2. Mr. Villemure, if you please.
Monsieur le Président, j'aimerais déposer.
I'd like to move Amendment BQ2, which is in a similar vein to my previous colleague's amendment. The purpose of the amendment is to include the election platform of a political party by replacing line 25 on page 75 of an electoral platform by a political party, etc., etc.
Thank you, sir. Is Mr. Gahir?
Thank you, Chair. So the amendment would alter the definition of a political or governmental process under the proposed act to allow the governor and council to set out additional processes in this definition through regulations. So it's unclear what will be set out through the regulation that wouldn't already be captured through the broad and non-exhaustive definition of political or governmental. But I'd like to get the officials' word on this.
May I ask you to repeat that, if you don't mind, Chair?
That was quite fast. I'll slow it down. So this amendment, as we know, would alter the definition of a political or governmental process under the proposed act to allow the governor and council to set out additional processes in this definition through regulations. And then we know that, as drafted already, political or governmental process is non-exhaustive, and it's intended to include any political or governmental process. So to me, as far as I can read it, it's unclear what would be set out through regulations that are not already covered by this broad language.
Thank you, Chair, for that question, and thank you for the member for repeating it. The list is, as my colleague here mentioned, it include a non-exhaustive list and is quite broad in terms of government and political process. And a commissioner would be free to interpret that in a specific context. And so the intent was to create a list that was non-exhaustive. That's what's included here, and I think it includes a lot of issues that would be captured within a government political process.
Discussion on BQ2. Seeing none, shall BQ2 carry? No. I think that's a no. This brings us to NDP 5. Mr. McGregor.
Thank you, Chair. I think this is a great segue after we just talked about the benefits of having harmony between the SOIA and Part 4 of this Act. And so essentially what I have asked the amendment drafters to do was to take the definition of public office holder, which is on page 30 and 31 of this bill. That is a definition which is being added to the Security of Information Act, and I have asked them to include those exact same components into this new act so that the it would basically be exactly in harmony with the SOIA.
Very well. Any discussion? Seeing none. No, I apologize. Ms. O'Connell, go ahead.
Thank you, Chair. I can't see witness names because my eyes are going, and now you can't see me. So, thank you, Chair. I'm just a question of this to officials. Why was the reference to the Lobbying Act specifically made? What benefit does it have? And specifically, are there unintended consequences of this amendment?
Thank you for that question, Chair. The reason that the reference in the legislation used is the Lobbying Act is because the registry does have some similarities to the intent of the Lobbying Act, and by referencing the definitions in the Lobbying Act, it allows us to align with that piece of legislation. But also, if the Lobbying Act changes, then automatically the definitions of public office holder in FIDA would change because it's being done by incorporation by reference. And so it would always be up to date. And so the amendment would lay out similar or the same language, but if the Lobbying Act were to be amended, then the FIDA and the Lobbying Act would be different and could create some confusion for individuals who might have to register in both pieces of under both pieces of legislation.
Thank you. So then, if the intention is just to keep the Lobbying Act language, but without having to come back in the event it changes, I'm more comfortable with leaving it as a reference to the Lobbying Act so that this bill doesn't become outdated the second the Lobbying Act changes. And I would be, so I accept and appreciate the intention to kind of put it, the amendment to put it out there very clearly, but I do worry that the timing of, one change to one piece of legislation and then a review of another, I would rather keep it to allow that it can be automatically in alignment. I don't know if there was anything else that to our officials that they wanted to add on this.
Yes, if I may, just to point out, part of your question was the impact of the amendment. It would misalign, or it would misalign the coming into force of the provisions in the definition, because we've broken out, or the legislation breaks out the coming into force of different parts of the law as it applies to PTs and Indigenous governments, and so the amendment would create confusion with that and impediments.
Now, I remember, thank you again, Chair, I remember that specifically in this legislation, there is coming into force that is different for Indigenous communities, so that there is an opportunity to further consult and make sure that there's an understanding of how legislation might impact them and how we can work and make sure that we have proper consultation. Are you suggesting that then this amendment would put all of the coming into force under one regime and not have a separate for Indigenous consultation?
No, I think, Chair, what I'm suggesting is that because of the coming into force, the reason for the mismatch or the opportunity to bring into force Indigenous application later was to allow for consultation. And because of differences in governments and how the definition of public office holder may apply, we wanted the benefit of having those consultations so that we can align the coming into force properly and the application to Indigenous partners properly.
I see. So the coming into force would be part of that consultation for the Indigenous piece. Okay, thank you, Chair. For that, I feel like I'd be very comfortable if it's directly in line with the Lobbying Act, and as that gets updated, so does this portion of the bill, and I'm comfortable with that. Thank you, Chair.
Yeah, two things. I mean, we just had a big conversation about how it was important that this new enactment lines up with definitions in the SOIA. So now we're having a completely different rationale argued by my Liberal colleague. And second of all, if you look at the existing Lobbying Act, I'm just bringing it up here, Section 2.1, because that is what is referenced. It does not appear that there is any mention of MP's staff, whereas my amendment is seeking to specify that specifically. it says in the new B, members of the legislature of a province or persons on the staff of such members. So, I think we just had an argument regarding the previous one of the previous amendments that we should respect harmony with the Security of Information Act. I believe this is trying to bring the bill in that same spirit.
Any further discussion? Seeing none, shall NDP 5 carry? No. So that brings us to NDP 6. So if NDP 6 is moved, NDP 7 and BQ 3 cannot be moved as they are identical. Mr. McGregor, did you wish to move NDP 6?
Yes, I do, Chair. So I know, thanks to our officials, because I know in witness testimony when I had asked them about this, they had said that they did interpret provincial or territorial political or governmental processes to include municipalities. I appreciate that, but I'm always a favor of specificity where we can bring it in the law. And again, this is bringing it in harmony with the Security of Information Act, which I think does make specific reference to municipal government. If you just bear with me, if I go back to the amendments. Yeah, I do believe there is a reference. If you look at the bottom of page 31 of the bill, it does specifically reference in the application part municipal, political, or governmental processes. So this is bringing this part 4 into harmony with what's going on page 31.
Thank you, Chair. As I continue on my journey to become a licensed lawyer in Canada, I've actually just recently done my constitutional law exam. And if I remember my lessons correctly, municipalities are constitutionally actually creatures of the province itself and exercise all of their authority through provincial devolution. So my question, I guess, for the officials is, can you confirm that even without these amendments, that the political or governmental processes of municipalities will be covered?
Yes, Chair.
Ms. O'Connell? Oh, I'm sorry. Go Mr. McGregor, then Ms. O'Connell.
Thank you for that answer. May I ask why then the amendments to the Security of Information Act felt it necessary to include a specific reference to municipal political government processes when, if they are in fact a creature of the province, you already have it covered in B? I'm just wondering.
Mr. Scrivens?
The intention there was to be as specific as possible because at the time we were specifying a level further, which was at the school board level, which is now incorporated in a secondary definition. But so in it's a bit technical and complicated, but in attempting to assert a very broad scope for that provision that included school board elections. The intention was to specify all levels and orders of government down to school boards.
Chair, and the one part I liked about Mr. Scriven's answer was an attempt to be as specific as possible. I think that's great, and that's what we should be attempting to do here.
McGregor, any further discussion? Ms. O'Connell.
Thank you, Chair. I believe, or maybe through you to the officials, that one of the issues with this was the fact that there is no, is it the coming into force clause for something referred to as B.1? So even if we make that amendment, the problem is the fact that B.1 then isn't referenced.
So thank you, Chair. So the there are 3 coming into force provisions, 1 for A, 1 for B, 1 for C. And there are 3 different. If you decide to add B.1 as a separate category, there is no equivalent coming into force provision for B.1.
We just added in B, provincial, comma, territorial, comma, or municipal, that the coming into force issue would not be an issue.
That's
and would
correct.
do what the amendment of Mr. McGregor is.
That's correct.
So, Chair, I don't know if this will be ruled in order or not, but I would like to make a sub-amendment that we delete B.1 and instead move within B, provincial, comma, remove or, territorial, comma, or municipal, and then continue with the political or governmental processes. And I have extra copies if anyone needs them in both official languages.
Could you distribute that, and we will suspend, because it's meeting suspended. This amendment would have been required to be, it's an amendment, not a sub-amendment, because it amends, so it's not in order according to our rules at the current time. All right? So, Mr. McGregor, go ahead.
Are we, as a committee, allowed to challenge the chair on that?
You can always challenge the chair. But this change basically would add another B to the paragraph, to the text. So you'll have 2 Bs. It makes the bill unintelligible. Right? This is my advice. So, Mr. McGregor, are you done?
I'll let Mr. Chong.
Mr. Chong, go ahead.
So, Mr. Chair, so in other words, what you're saying, we have the option to negative NDP 6 and then consider another amendment, which has been essentially proposed by Madam O'Connell.
Except we're not allowed to do amendments. We can only do amendments to the bill that were submitted prior to 4 p.m. on Friday. Of those amendments that were submitted prior to 4 p.m. on Friday, we can do sub-amendments. This change would require its own amendment, and therefore it's excluded by what we're allowed to do under the terms of the House order. Potentially, though, we should make a list of these things and deal with it at report stage when it gets back to the House.
And Mr. Chair, just to another point of order, NDP 7 appears to be exactly the same as NDP 6.
Well, NDP 7 cannot be moved, nor can BQ 3 because NDP 6 was moved.
I see. There was just, okay, I understand now. Understood. Thank you, Mr. Chair. So there's no way to amend NDP 6 in the way that was suggested by Madam O'Connell?
It appears not, because it says to take this line of the act and substitute this text. What Ms. McConnell's change is trying to do is add something to the previous line of text. Right? And we're kind of caught between Ms. O'Connell, please.
Chair, could we ask for unanimous consent to accept this as a sub-amendment?
You can ask, but the chair was going to rule it as out of order, so you'll have to override the chair.
So, Chair? Chair.
There will be the repetition of text in the bill.
And it will produce a repetition of text in the bill, right?
Chair, in all seriousness, I understand and recognize the importance of the House motion, but I think it's silly that we have an opportunity to make legislation better in this committee, and I think we have some consensus in how to do so without the unintended consequences of a coming into force issue. So, I mean, yes, we can do it at another stage, but I think if there is will amongst this committee, and while I respect the law clerk's ruling and your ruling, I think, you know, these aren't normal constraints we're under, and we have an opportunity to actually just make the bill a little bit clearer, and if we have support, I think we should do so.
Let me pause and talk to my friend here. Mr. McGregor, go ahead.
So with great respect to you, Chair, because I understand the confines you find yourself in, I would move formally to challenge you, and as a committee, the motion would be to accept the amendments as proposed by Ms. O'Connell. This is a minor fix, and really it lends itself to making the bill more clear.
Let's make this proper. So Ms. O'Connell's request is to amend the previous line as stated. I rule it out of order. You're challenging me. Okay, the question then is, shall the decision of the chair be sustained? I'm outvoted. Okay. So,
There's debate on that.
so is there debate on that change? No debate? Are we clear on what we've done here? Right? Okay.
If you'd like
All
a
right.
suspension, we're just explaining to them how.
You know, short time while we get squared away up here.